Assalamualaikum and hi, my name is Farhah Najiha binti Muhammad Fairuz. My place of origin is Kampung Baru, Kuala Lumpur. My secondary school was MRSM Bursary. Then I furthered my study in Centre for Foundation in UiTM Dengkil doing foundation in law. So my aspiration in studying law would be to become like my father. So why my father? Because my father is a lawyer, so I want to achieve this degree to become like my father. But now I will give my legal opinion on issues arise due to COVID-19. So the first issue is whether MCO can cause breach of contract. Regarding this issue, the government has created the temporary measures for reducing the impact of coronavirus disease 2019 in bracket COVID-19 Act 2020. In part 2 of the Act, it mentioned about inability to perform contractual obligation. So, the inabilities of any party to perform contractual obligation arising from any of the categories of contracts mentioned in the schedule to this part shall not give rise to the other party or parties exercising his or their rights under the contract. So the categories of contracts are such as construction work contract, construction consultation contract, the performance bond or equivalent that is granted pursuant to a construction contract or supply contract, professional services contract, lease or tenancy of non-residential immovable property, event contract by a tourism enterprise, and religious pilgrimage contract. So if the contract is not under the list of contract protected under the Act, we must look at the force majeure clauses in the contract. So we need to look at the wording in the force majeure clauses, whether it mentions words like MCO, COVID-19, or words that are equivalent to it, such as pandemic, outbreak, act of God, or act of government. So, if those words exist in the force majeure clauses, then parties are protected from breaching the contract. If there are no force majeure clauses or the clauses does not mention anything involving COVID-19 or MCO, then the party unable to perform the contract due to MCO are at risk of breaching the contract. So, the second issue is, can Section 74 and Section 75 of the Contracts Act be applied for claim of damages due to the MCO? So, as I've mentioned before, parties under a contract that is protected by the temporary measure for reducing the impact of coronavirus disease 2019 Act 2020 are protected and there will be no breach of contract. Also, if the force majeure clauses mention situation or wording like the COVID-19, MCO, or which are equivalent to it, then they are also protected from breaching the contract. While if there are no mention of the situation, then there will be breach of contract. So yes, party affected can apply for claim of damages under Section 74, where an innocent party may claim damages from the party in breach, and Section 75, which talks about liquidated damages. Thank you. Now I rest my case.